Yeah, this really comes down to the letter of the law, and who you trust depends on your interpretation of it.
This is a national thing that can affect millions of Americans.
That had you prove some type of special need in order to get a permit.
The co-chair of the Second Amendment Caucus, Mr. Massey.
It is reported from the Rules Committee. Against any resolution reported.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
That as the law is written, the FRT-15 is a perfectly legal.
Breaking news. So the litigation against the regulation of force reset triggers has ended in a devastating blow for the ATF. ATF's actions on force reset triggers. Recently, a federal court judge issued an order that is preventing the ATF's present attack on force reset triggers. This case involves Judge O'Connor's recent order regarding force reset triggers, and it's a significant development in the ongoing legal battle between the ATF, rare breed triggers, and other parties. The rare breed FT-15 force reset trigger has been at the center of a complex legal dispute. The ATF alleged that this trigger meets the NFA, National Firearms Act, and GCA, Armed Control Act, definition of a so-called MASH arm. As a result, the ATF claimed that these triggers were subject to registration requirements similar to actual machine arms. The ATF sent a cease and desist letter to rare breed triggers in July 2021, stating that the possession and transfer of these triggers outside of the GCA and NFA restrictions could lead to criminal penalties and fines. Rare breed triggers initially filed a lawsuit against the ATF in the Middle District of Florida, but the case was dismissed due to missed court filing deadlines. Subsequently, rare breed triggers filed a different lawsuit in North Dakota, which was also dismissed because of venue issues.
That had you prove some type of special need in order to get a permit.
The co-chair of the Second Amendment Caucus, Mr. Massey.
And we reached the owner of Rare Breed by phone. They said they're resubmitting evidence.
It is reported from the Rules Committee. Against any resolution reported.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
California knows how to do these things well, and they know how to work around things so that they can just draft this new law.
However, in the latest development, Rare Breed Triggers partnered with the National Association for Arm Rights to file a lawsuit against the ATF in the Northern District of Texas. This case was assigned to Judge O'Connor, who has presided over several other notable firearms-related cases. Simultaneously, the U.S. government filed a lawsuit against Rare Breed Triggers in the Eastern District of New York. In this lawsuit, the government alleged that the triggers sold by Rare Breed Triggers were indeed MASH guns under the NFA and GCA. The government also accused Rare Breed Triggers of various misconduct, including mail and wire fraud, threats to the ATF and other federal agents, and other offenses. In the New York lawsuit, the federal district court ruled in favor of the government and granted a preliminary injunction against Rare Breed Triggers, preventing them from marketing or selling their triggers and devices. However, the recent order from Judge O'Connor is a significant victory for Rare Breed Triggers and NAGR. Judge O'Connor used the precedent set by the Ninth Circuit's decision in the Caro case, which dealt with bump stocks, to challenge the ATF's actions regarding force reset triggers. Both cases revolve around the ATF's attempts to redefine the term MASH gun and expand its scope to include various accessories and devices. To grant a preliminary injunction, Judge O'Connor needed to find that there was a substantial likelihood of success on the merits, that irreparable harm had been suffered, that the balance of hardships favored the plaintiffs, and that the public interest was not harmed by the decision. Judge O'Connor's ruling in favor of the plaintiffs is a significant setback for the ATF's regulatory efforts in this area.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
To the ATF for reconsideration, he added, "Our legal position remains."
If you did, you still couldn't use it because you couldn't go about your daily life without crossing through some type of sensitive location.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
This is a national thing that can affect millions of Americans.
Federal court judge grants injunction in favor of plaintiffs and NAGR. A judge in the federal court has issued an injunction, which is a significant new step in the law. This injunction precludes the ATF from advancing with its measures regarding force reset triggers. The plaintiffs in this action, as well as the NAGR, have been awarded a substantial victory as a result of the order that was just issued. To decide whether or not to issue an injunction, a court must take into account a number of criteria. The chance of winning the lawsuit on its own merits is one of the most important considerations. Following consideration of all of these aspects, Judge O'Connor came to the conclusion that the plaintiffs and NAGR ought to be awarded a preliminary injunction in their favor. The question of whether or not the ATF's expanded definition of a mash gun goes beyond the bounds of the agency's statutory jurisdiction is one of the most important considerations in this case. The plaintiffs asserted that the regulation issued by the ATF, which enlarged the definition of what constitutes a mash gun, was arbitrary and capricious, and Judge O'Connor agreed that there was some validity to these claims. He refuted the government's argument that he should merely adopt the decision of the Federal District Court in New York, and underlined that his decision was based on the unanimous panel ruling in Carrio issued by the Fifth Circuit. The government had argued that he should do so.
Semi-automatic trigger. The ATF said that they don't comment on litigation.
And call on young people to continue leading efforts to end gun violence,
tearing apart families and making our streets less safe.
But let's just say that you actually did get a permit under the original SB2.
Now today, as you all know as well, we're also marking National Gun Violence Awareness Day.
There are many areas, as you might imagine, especially when you're dealing with firearms, where we just don't know.
According to Judge O'Connor, force reset triggers, also known as FRTs, do not fire several rounds with a single pull of the trigger. As a result, they do not meet the criteria for being classified as mash guns in accordance with the statutory definition. He also refuted the premise that rifles outfitted with FRTs should be classified as machine guns based on their rate of fire because it was presented by the ATF. Judge O'Connor underlined that Congress has the authority to alter the statutory definition if they desire to include characteristics like rate of fire. However, until that time comes, such considerations do not affect the finding that FRTs are not machine arms. Judge O'Connor emphasized that Congress has the authority to amend the statutory definition. In his order, Judge O'Connor took into account other factors, including the possibility of irreparable harm. He made the observation that there is a real possibility that the ATF may bring charges, not just against the identified plaintiffs, but also against additional individuals. The fact that the ATF is rumored to have visited the residences of the plaintiffs and other individuals involved in this case adds to the worries regarding the possibility of injury. In the end, Judge O'Connor came to the conclusion that the best way to protect the general public would be to issue an injunction. He added that the government has not proven that it would be damaged in any manner by the injunction, whereas there is evident harm to the people if it is not in place. He also stated that the government has not proved that it would be harmed by the injunction. As a consequence of his investigation, Judge O'Connor decided to rule in favor of the named plaintiffs as well as NAGR and issue a limited injunction. Nevertheless, he turned down their request for a countrywide injunction, which is a significant development in this particular legal dispute.
So in California, it was extremely difficult. California had to get rid of that good cause or just cause requirement.
Then the White House walked back that statement.
We filed formal petitions for rulemaking through the appropriate channels.
That as the law is written, the FRT-15 is a perfectly legal
of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
Of 2022. Now, when it was originally introduced, it was the worst carry bill that I have ever seen.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
Federal court grants limited injunction. It is essential to emphasize that the injunction that Judge O'Connor issued in this matter has a circumscribed application. In spite of a request for a worldwide injunction, he decided to limit its applicability just to the identified plaintiffs as well as NAGR and the members of that organization. In addition, within the order, he included a clarification section to underline that his decision would not contradict the prior ruling made by the Federal District Court in New York regarding Rare Breed Trigger's ability to sell and advertise their products. This was included to emphasize that his decision would not overrule the previous judgment. In essence, Rare Breed Triggers were fashioned from the safeguards established by the ruling issued by Judge O'Connor.
This is by far our most popular product we've ever sold. By far, hands down.
I think worse than that, sir, you will see millions of otherwise law-abiding citizens
shall not be infringed.
Take all of the guns from all of the people. That's their goal.
Because Bruin said that that's unconstitutional, so they drafted SB 2, which was originally introduced back in December.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
The listed plaintiffs, NAGR, and their members are the ones who stand to benefit the most from Judge O'Connor's protection. However, there is a chance that other companies that are linked with NAGR could also be covered under this provision. However, rare breed triggers are not going to be harmed by this particular litigation in any way because of a previous ruling made by a federal court in New York. Because the ATF takes an active role in the process of enforcing rules, it is imperative that extreme caution be used whenever dealing with force reset triggers or other things of a similar nature. Even though this order provides the plaintiffs and members of NAGR with relief that is to their advantage, it is essential to keep in mind that the ATF has a long history of appealing similar injunctions. Therefore, the result of this legal struggle is still unknown, and we must wait to see how it plays out before making any decisions. As a friendly reminder, the information presented here is not intended to be taken as legal advice.
Yeah, this really comes down to the letter of the law, and who you trust depends on your interpretation of it.
SB 2 was California's answer to the Bruin decision because just like New York,
and in the House in this coming week, on Monday,
we are taking action. We are getting things done, and we are trying to save lives.
Today, Vice President Harris will also deliver remarks at John Lewis High School, where she will talk about...
So while everybody's distracted with New Mexico's ban on open and concealed carry,
the ATF wants the production of this to be stopped in its track, but the manufacturer says they're fighting back.
Individuals are urged to exercise caution and ensure that they remain updated regarding developments in this case and topics relating to it. That's all for this video, folks. We'll see you next time.